Good morning, everyone. I am Dr. Rohit Goel, Associate Professor in the Department of Forensic Medicine at Sri Lakshmi Narayana Institute of Medical Sciences, Puducherry. Today, we will be discussing an important topic medico legal aspects of disclosure of medical errors. This module is prescribed by NMC under Aetcom Module 3.2 and focuses on ethical, legal, and professional responsibilities in medical error disclosure. Medical errors are inevitable in clinical practice, and we physicians handle them on routine basis. But how to ensure patient trust and be legally valid and maintain professional integrity becomes a question in many of the situations. So let's start with our discussion on this particular aspect and take a case scenario as prescribed by ADCOM module 3.0. So in this module, a 5-year-old girl is brought to the pediatrician for a regular follow-up and immunization booster. The doctor, occupied with other patients, instructs a nurse to prepare the injection. Later on, he goes to injection room and administers the injection. After some time, the nurse comes to the OPD room and tells the doctor that injection is ready. Now the doctor is confused about how come injection be ready now when he had already administered the injection to the patient. On further questioning, the doctor realizes that he has wrongly given gentamicin injection to the patient, which was actually meant for some other patient. From this given scenario, let's discuss on medical errors in clinical practice, approach to disclosure of medical errors, and what would be the consequences of failure to disclose such medical errors, including medico-legal aspect, social aspect, and loss of trust. So these points have been asked by ATCOM module for the discussion with respect to medico-legal, social, and loss of trust aspect when doctor fails to disclose the medical error. Now let's begin by reviewing some already available data on medical errors. In this context, a report of 1999 by Institute of Medicine, the name of the report is "To Err is Human" becomes very relevant. In this report, it was highlighted that the number of deaths approaching 44,000 to 98,000 annual deaths in hospitalized patients happened due to medical errors, more than those caused by road traffic accidents, which was around 43,458. The report emphasized that the need of patient safety initiatives and error disclosure policies. In this context, the Joint Commission Journal on Quality and Patient Safety in April 2006 published an article on the number of articles which were addressing error disclosure for the period from 1970 onwards. We can clearly see that a flat line is seen till 1980s, and after that there have been a consistent rise in the number of publications with respect to patient safety, with respect to informing patients about it, and with respect to professional learning. After this, we can see a histogram graph which discusses the factor which hinder a physician from disclosure of such medical errors. And we see that there are many things which make a doctor fearful of disclosing these errors. These include professional repercussions, legal liability, blame, lack of confidentiality, negative patient and family reaction at the time of disclosure, the event may turn out to be violent. Doctor may be feeling ashamed, humiliated, or embarrassed with respect to these errors. And there are issues with respect to perfectionism in the practice. When a professional feels perfectionist, then it might be difficult for them to admit their errors that have happened. Guilt, lack of anonymity, and lack of professional forum are some of the factors which hinder a physician from disclosing his errors. Now, understanding these barriers is very much important to foster a culture of transparency and accountability in healthcare. Now, let's take a step towards understanding the application of safety principles in healthcare. First, we see that the safety is understood as freedom from accidental injury, and safety is compromised because of occurrence of an error. Now, error can be understood from a practical standpoint that it can be an error of planning or it can be an error of execution. Error of planning is when there is a lack of planning or a defective plan is chosen. In execution error, the planned activity has already been outlined, but it is not followed in a proper manner as it was desired or planned. In this context, it becomes important to understand that Reason's Swiss cheese model highlights that errors arise due to multiple system failures, which, when aligned together, will lead to occurrence of an error and can lead to patient harm also. Looking back at the practice of evolution of medicine over a period of time, we see that there is a transition in trend from paternalism to voluntary error disclosure. Historically, the patient involvement was very minimal or even very little with respect to their decision on what kind of treatment they would undertake. The doctor's role was primary in this context, and here the doctor took the role of a parent. That's why the term paternalism applies in those circumstances. Here, the primary concern was for life. Later on, we saw that informed consent became a key principle, reinforcing patient rights and autonomy. Today, the focus has shifted towards voluntary error disclosure when transparency and ethical accountability in patient care are being emphasized. Historically, we see that the concern for patient safety began gaining attention as early as 1960s. In 1964, Schimmel reported that 20% of admitted patients in a university hospital suffered from iatrogenic injuries, and 20% of them sustained serious or fatal injuries. In 1981, similarly, Steele did the study in teaching hospital where he found that 36% of injury patients sustained iatrogenic event and 25% were serious or life-threatening incidents. Similarly, in 1991, Leap et al. Studied in population that 3.7% of studied individuals had sustained disabling injuries as a result of medical treatment, and 28% have had negligent care in those in those studied cases. In 1991, Patel studied in a teaching hospital and found that 64% of cardiac arrest at a teaching hospital were prevented. In 1991, as we have emphasized earlier, that Institute of Medicine published this report to Err is Human. And what really shocked the world when IUM went ahead to equating these deaths with graphical analogy of one jumbo jet crashing every day. So this this accentuated and emphasized on a critical need for intervention. As a response, in 2005, US government introduced a Patient Safety and Quality Improvement Act to encourage safer healthcare practices. Further strengthening of this movement, the American Recovery and Reinvestment Act of 2009 allocated $36 billion in incentive to hospitals. This was aimed at promoting meaningful adoption of technology to enhance the quality and safety in patient care. And with this movement, we can see that there was arrival of electronic health records also. The legislative measure marked a significant shift towards prioritizing patient safety in healthcare systems worldwide. Now, what is the current report on global burden of these particular errors? In 2013, a study published in BMJ Quality and Safety Journal in 2013 estimated that among 421 million hospitalizations in the world annually, 42.7 million adverse events are occurring, which manifest as 23 million disability adjusted life years. And two-thirds of adverse events occur in low to middle income countries, including India, where we have never seen forthcoming of any such data. These data underscore the need for robust patient safety mechanisms. At this juncture, we can establish that patient safety issues, including error disclosure, are important, relevant, and pose significant critical challenges in healthcare. But what is the legal statute? What is the ethical stand in the medical world today with respect to error disclosure? Is there any statement in the statute in India? What is the code of ethics, NMC code of ethics saying about this? Or are there any prescribed experts or medical bodies with respect to error disclosure? Let's go into detail in this particular domain. As per Article 21 of Indian Constitution, there is right to life and personal liberty. Although it does not explicitly mandate error disclosure, but it can be interpreted with respect to a patient that right to be informed about errors affecting their treatment is an implied one. From a doctor's standpoint, however, a counter argument can also be put in place, stating the Article 20 subclause or clause 3, no person shall be compelled to be a witness against himself. So, in this standpoint, it is important that law does not mandate such error disclosure from the side of doctors, but impliedly or indirectly says that that patients should also be informed about these errors when it is affecting their life and personal liberty. Now, to continue ahead, we take another reference from a case that was decided by the State Commission. The case is cited as Dr. Neeraj Sardana versus Srimati Rashmi Kakkar and another. In this case, the dentist had performed a dental procedure on the patient. The patient, following the procedure, continued to have pain, and she went on to consult another doctor with respect to her problem. The second doctor informed the patient that her mandible is fractured. Now, when the patient came to know about such thing and understood that the first doctor had failed to reveal such condition to her, she went on to file a claim against the first doctor. And court favored in the favor of patient also. And court here highlighted that doctors should not refrain from informing the patient in these circumstances. Next reference we take is from National Medical Commission guidelines on ethics, etiquettes, and conduct. First set of guidelines were prescribed in 2002, and the latest version, which is not yet in put into place in function because of its retraction later on in 2023. But for reference point, we have found that they do not have any explicit statement mandating error disclosure. Both the publications by NMC do not emphasize or make it mandatory for the doctors to disclose these errors. Next reference that we can take is from Charter of Patient Rights by National Human Rights Commission. This commission published a list of patient rights, citing that patient rights are human rights. In these rights, if we go through, there are a variety of rights that have been emphasized. Yet the most important one remains right to be informed about the physical condition at all times. Indirectly, it can be interpreted that the patient has to be made aware of all the health condition at all times. And definitely the medical error should also be disclosed. However, there is no outright statement to state that medical errors, if sustained by the patient, should be informed and what should be the approach with us. Next, we have NMC registered medical practice. Next, we have additionally, we have taken reference from NABH and IMA guidelines and publications, and we have not found any particular statement on error disclosure by these medical bodies. Now let's apply medical ethics principles on this particular problem of error disclosure. There are four principles of medical ethics. First, autonomy. From autonomy perspective, patients have the right over their own body. Thus, patients have right to know about errors affecting their health. Second pillar talks about beneficence. Disclosure helps addressing the error and prevents future occurrence and even complicating the present health condition. So, in this context, it becomes relevant that both autonomy as well as beneficence emphasize that error disclosure should happen. Third pillar of medical ethics is justice, ensuring fairness in medical practice, mandating that the patient should be informed. We can try to imply it in an indirect way. If a healthcare professional happens to treat one of their close relatives, now it raises a question whether the patient who is a close relative of healthcare professional will be informed about this or not. And if the close relative has to be informed, then definitely it should be applied to other patients also. And lastly, we see non-maleficence, which in simple words means do no harm or primum non nocere. So, not revealing an harm will definitely be totally against this particular principle because not disclosing the error will anyway complicate the management of the patient. Now let's look at the international practices on medical error disclosure. In United States, the National Medical Error Disclosure and Compensation Bill was proposed in 2005, proposing the protection of doctors who disclose medical errors. This act was not passed by the parliament. However, we see that there is a provision of apology laws which is already applicable in the state of Massachusetts and other 39 states and District of Columbia. The what now let's understand what is the meaning of this particular law, the apology law. The law states that whatever statement is made by the doctor for disclosure of medical error in interacting with the patient, at this instant, whatever statement is used by the doctor cannot be used as evidence in the court of law for prosecution of such doctor. In Japan, at Hiro Hospital, one of the patient was administered a wrong drug and patient died. The CEO of the hospital was charged with a criminal case, leading to implementation of formal medical error investigation systems. In Canada, some provinces even mandate by law this disclosure of medical errors, as we see in Ontario, Gerula versus Flores. On this slide, we can see a movement towards medical error disclosure. And what are the impacts of non-disclosure of medical errors? In routine circumstances, let's imagine a patient is taking treatment and nothing is going wrong. Patient parties and relatives are also satisfied with the treatment and in a relaxed way. They do not anticipate any occurrence of these particular errors. Suddenly, the patient and condition becomes severe and patient becomes unstable. That definitely raises the issue, raises a concern in the minds of the patient that there is something wrong, anticipation of wrong is there. This anticipation of wrong can make them go for a second opinion. And once they come to know about this occurrence of error, they get the knowledge to sue. So active hiding by the doctor can make them even desirable to sue the doctor. And ultimately, case can be reviewed by the courts also. They can take help of legal advisors and case can be filed against the doctors. Now, from the side of doctors, what happens in these circumstances? Whenever some error has happened, it can be active wrongdoing or it can be an accidental thing. But till it is an accident, it is okay to be admitted. What happens afterwards becomes problem. Because when a doctor does not disclose this error, he has to make active attempts to hide it. And to hide it, there will be some sort of falsification of records. This record falsification will not be restricted to one particular thing because doctors and their system have not put in place any sort of policies when such issues arise. So definitely, if there is no policy with respect to it, it will lead to repetition of the same thing. And once a problematic behavior is repeated, it will lead to adoption of wrong habits and wrong personality. Ultimately, these cumulated efforts of hiding will come out from a case review in the court of law and it can lead to lawsuits, civil, criminal, and even consumer lawsuits. And ultimately, state medical council can also take a disciplinary action against the doctors. From a third person's perspective, let's try to put this situation. From a general perspective, a doctor-patient relationship is that one of a trust relationship. And doctors should take active efforts in healing of the patient. So hiding a medical error is likely to be understood as an unprofessional conduct by the courts or any third person, even media, may go on to publish these kind of errors if they are found out, and there can be media reports. Today social media is very active in this particular area where people can post directly. When these issues come across the courts not only give the compensation, but they can always exercise punitive damages to set an example on the other physicians that doctors should disclose these medical errors. Now, when we see handling of medical errors, from handling of medical errors from a practical, okay, this slide gives an idea about practice transition in handling of errors. There are two kinds of thinking here. One is a reductionist thinking and another is a holistic thinking. Reductionist thinking focuses more on the short term gain rather than the long term. Here the focus is to avoid and to not talk about. The primary agenda of reductionist thinking is that we do not have control over the errors. Harm is inevitable. Quality and safety is not our work, and it relies on practice of certain clinicians and certain people who become heroes of medical practice. But that's not the truth. The actual truth is that healthcare is a team exercise. Here, everybody has some responsibility, has the responsibility within the domain of their practice. And if we if we pose responsibility on every individual, then definitely we can prevent these harms and we can maintain systems with respect to not to avoid these particular harms and errors. So we have to design integrated systems which deliver a safe health. So this is the approach of holistic thinking. Some taking it further, reductionist thinking attempts to deny and defend and shut up and fight approach with respect to medical errors. Responsibility of error is usually put on the individual provider. Here, one scapegoat will be chosen, and there they will be bearing the brunt of all negative emotions directed out of occurrence of error. And this scapegoat is usually the last provider. The shame and blame culture is prominent in this particular kind of thinking. Whereas if we take holistic thinking approach, it talks about systematic process to promote communication. It advises improvement of systems to maintain a transparent culture and not to put individual for shaming and blaming. There is no one individual who is responsible for this particular phenomena of error. Now let's, towards the end of this particular session, I would like to discuss a case example, understanding the difference between reductionist and holistic thinking. This particular example gives out what happens when reductionist thinking is employed. So here we see that a patient P is undergoing herniated disc repair under general anesthesia. A new anesthesiology resident is assigned the case without orientation training. So one important aspect from the side of management of this orientation is missing. During surgery, P receives phenylephrine, which induces severe hypertension. That is a known side effect of the drug. While responding to the event, the resident makes a syringe swap error, due to the similarly colored vials. Now, this is also one of these slice of cheese as brought out by James Region, where this also could have been avoided, that color mismatch, color resemblance can lead to occurrence of these kind of errors. At this instance, the resident gives labetalol, inducing an intraoperative cardiac event. Patient decompensates and dies. Now, what happens when this case moves ahead? Hospital's general counsel advised the legal experts from the side of doctors advised that all statements which are to be put to the patient have to be cleared by them before putting it to the patient. When it came to communicating about the error, the lawyer alone went to speak with the patient's family. Hospital's risk management representatives guided all the healthcare staff to not speak or communicate with the family at all. Now, this raises many doubts with respect to how the error has been handled by this particular team. Later on, when these kind of things happen, everybody tries to defend their own interests. The anesthesiologist, head of the institution, anesthesiology head, settled the lawsuit with the family independently, in part by saying that he would make the resident pay for her error by making sure that she loses her license and would testify against the hospital for its incompetence. The surgeon in that particular case did not settle and litigated and won the case after fighting for a long time and spending $300,000 in legal fees. Hospital also settled the suit with the family with with respect to an undisclosed sum. And anesthesiologist resident was distraught by this error and quit her residency herself. The family endured 4 years of painful and emotional litigation process, dislikes the providers, and appeared on local media to tell their story. So, this reductionist thinking has brought only loss for everyone. Loss for the family, loss for the surgeon, loss for anesthesiology resident, and loss for the hospitals also. I would like to end this presentation by a quote from the father of our nation, Mr. Mohandas Karamchand Gandhi. He states that for confession of error is like a broom which sweeps away the dirt and leaves the surface brighter and cleaner than before. I feel stronger for confession. For further reading, I recommend that students can refer to Unaccountable by Marty Makari, The Price We Pay by the same author, Checklist Manifesto by Dr. Atul Gawande, Emperor of Melodies by Siddhartha Mukherjee, and Patient Safety by Abha Agarwal. Thank you for active listening. I hope you find the session productive. Thank you very much.